professional advisors is benefit, but you need to relook at things. You Control-Alt-Delete to your business system, you're starting again. You need to check that it's there. If you don't, I draw you back to the problems that you sit with. Perhaps you get through the court case. Perhaps you're not sued. But how do you explain this to your fellow directors and your fellow shareholders that you haven't taken steps to comply? It's a very difficult scenario. Okay, so I can now only ask for questions, which I'm sure there must be 1,000 questions, which you might not want to ask now. Please, my email address, my telephone number, use it if you wish. Yes, Eric.
Just the product liability. I mean, there's the 6 months where you can return away from it. But I mean, how long does product liability last? I mean, that fridge breaks down and kills your maid 7 months after you bought it. Is it out the act, or does product liability actually carry on longer than that?
Well, the product liability you would have additional rights in terms of your 3-year prescription, which is your normal South African law, your common law rights. Your common law rights are not limited by this act, no. But you'll still have that. So that
someone can have a product liability 5-6 years after purchase against a supplier.
Well, remember that you would be bound by the limits of the Prescription Act, which determine that your right of action would disappear 3 years after your claim arose.
Okay, now I'm not talking about that. I'm saying, let's say you buy a product today and it fails 4 years from now.
Yes.
What rights do you have under this act? None.
No.
That is 6 months.
Yeah.
We've got a funny, we sell used cars.
Yes.
And a used car can be 7 years old.
Yes.
But you still have a 6 months.
Worrying.
But it's difficult to guarantee a 7-year-old product.
You see, the other thing is there's been debates on what's buying things footstoots. Okay, I mean it creates all kinds of problems, because there's a school of thought that says that footstoots is in fact a condition. So you're disclosing the condition of the vehicle to the consumer. There's another school of thought that says no, you've got to identify what the defects are in this vehicle. The other part that's been very scary that we didn't touch on today was that fixed-term contracts between natural persons can be terminated on 20 days' notice. So what does that mean for lease agreements? You sign a 5-year lease, 20 days' notice, it gets cancelled. Yes, you've got the right of being able to claim certain damages, but we all know that once the tenant is out, you lose your hypothec, you can whistle. You're never going to see him again. Yes?
What is the situation, for instance, you have 6 months or 10,000 cups or a kilometer, and the person does in 1 month 20,000 kilometers on?
So you're saying?
Let's say we have coffee machines.
Yes.
We give them a guarantee or a warranty of 6 months.
Yeah.
Or 7,500 cups.
I don't think
it does in 1 month 20,000 cups. Has it still got a warranty on for 6 months?
Well, that's an interesting question, but I think where it's going to go to is when you set out for him what this machine would do, did he disclose to you that he was going to be selling, or did you ask him, because this is now a positive or negative duty, did you ask him how many cups of coffee he was intending to do? And did you tell him that this machine is only good for 10,000 cups a month?
That's not just only good, but the warranty is either or, like on a motor car, you have 5 years or 100,000 kilometers. Yes. And now somebody does in 1 year 100,000 kilometers, so there is no 5-year guarantee on it.
Yeah, no, look, I think those are things that are going to fall to be tested. But I do think in your scenario of the coffee, it's going to be, the motor vehicle is not, I don't think, a good example, because a motor vehicle can do 100,000 kilometers in a year quite adequately. But the coffee machine might not be able to do that. It might well collapse at that kind of level.
Not really, we have coffee machines which do say.
Yeah. But it would be an interesting case there. Certainly something that one would have to research what the foreign guys have done about it.
Sorry, to go back to the example of the steak at Clive's house.
Yes.
Where does the owner's line prove that if Clive goes back to the butcher and say, this steak I bought here was poisoned? I mean, who proves the steak was bought at that butcher?
It's till slip.
Sorry?
There's till slip.
No, but it could be a stake from anywhere.
Yeah.
Take the shampoo, for instance.
It'll be the usual tests that you will have to go through in terms of current laws of delict about how, on a preponderance of probabilities, or how you would test it in a normal court.
But does the onus lie on the person that's on
The onus would lie on Clive to show that the product was bought there. Once it's established that that the product was defective, liability ensues. He doesn't have to prove wrongfulness or negligence. That's the strict liability portion of it. That's what's before, up until now got people off the hook, because they said, well, I mean, how could I have known that it was off? I took these and these and these and these steps. I can't be held liable. Now that is out the way. So that angle, I've just got to prove, in fact, that this is what happened, that I've suffered loss, and he's on the line. That's why insurance is the only answer.
You make terms and conditions.
Yes.
Can I say I exclude consequential loss?
Well, you see, consequential loss is not, in my view, dealt with in this Act. Direct losses are dealt with in this Act. Consequential losses have historically not been allowed in South Africa in any event because they amount to what they call pure economic loss. And the Supreme Court of Appeal has decided in many cases that you don't have a claim for pure economic loss in any event. So the liability would only flow insofar as this Act would give him rights. So I would say that you wouldn't even need to have that in your terms and conditions. Anybody else?
Do you have, as a trader, a positive obligation to warn about any possible events which can happen with your product?
I say yes. No, I say yes. I say yes because that's my reading of the Act. But I say yes because I think it's prudent. I think that a supplier who is confident of his product and wanting to avoid this kind of attack would go through, I would say, almost set up a checklist of the type of things that your staff should be setting out about your product. I'd say very definitely.
Will the packaging need to detail?
There's all kinds of things about packaging. That's a subject for a 3-week seminar.
And in which languages?
Yeah. No, that's a huge area. It's a huge area. Incidentally, one of the ways that you'll be able to escape liability in terms of this Act, in that if something was sealed and packaged, and you brought that into the country, for example, how would you be able to warranty its defects or lack thereof? So there's some kind of escape routes for a supplier there. Anything else? Okay.
Done.
Yeah.
All right, thanks very much, PJ. I'm sure you'll all agree that was a very practical presentation. I'm sure, I don't know about you, but the fear of God been put into me. By all means, give us a shout. We'll put you on to PJ. His details are there. But I think it's some of the things that he's discussed are critical that we as business people, us as trusted advisors, we bring it to your attention. That's what the whole purpose of this morning is to create an awareness, to try and add a little bit of value along the way. So please give us a shout. I mean, there are other things that PJ has mentioned that have raised some ideas in my head, and we'll circulate that by email to our clients. But I'm sure that you've all got some value out of this, and thank you very much for attending. Thanks, PJ.